So what do debtors sometimes do to shield and hide assets from creditors? Here's an article from the National Law Review which talks about how a business owner can shield assets from a judgment. And this is a way to shield a substantial portion of their assets, including ownership in your business. This is written from the standpoint of asset protection, not from asset recovery, but it does give a good insight into what a debtor or fraudster can do to hide their assets. Even if your business operates as carefully structured or limited liability corporation, this is not sufficient to protect from personal liability. In order to avoid losing your business, you need to put a comprehensive asset protection strategy in place. And knowing what these strategies are helps us as an agency to do investigations to uncover these assets. And it first says, what is asset protection? It involves using legal tools and structures to insulate your assets from third-party claims. So I'll bet you're one of those third parties that does not want your debtor to be insulated from claims. How do you get through that insulation? Well, businesses and owners can face liability in civil court proceedings. In fact, if the person does certain activities to shield assets, they can even have more liability. If we discover that a debtor has used fraudulent conveyances and asset concealment procedures to hide from a legitimate claim, they can have more liability. In fact, even a law firm that helps them hide assets or a bank may have liability. You probably saw in one of our previous videos where there was a bank that inadvertently, unintentionally helped a debtor hide assets. And because of that, the debtor was able to collect their judgment from the bank when the debtor didn't have enough money to pay him back. Business owners can face liability in all aspects of their lives. If a plaintiff knows that the likelihood of collection is high, the plaintiff is far more likely to proceed with litigation. This is where we do pre-litigation asset searches. So a lot of times a client will come to us and ask us to do an asset search on the debtor before they even start the case. First of all, it's to make sure that there are assets. Number two, to make sure that they're not being concealed. And the other thing sometimes to make sure that there's not too many assets. If you have a counterparty to a lawsuit that has $10 million in the bank and you're suing them for $50,000, that might seem like a great thing, but you may also find that they might spend $100,000 to beat you in the lawsuit and rack up your attorney's fees. So you want to make sure your debtor has some assets, but maybe not too many assets. What strategies can business owners use to protect their assets? Two major focuses. One is reducing the risk of liability. Well, if you're already suing somebody, that's already gone. Number two, protecting assets from civil and criminal judgments. It says the best way to avoid liability is to avoid a judgment at all, but sometimes that's too late. And in your case, as a plaintiff, you probably already have a judgment or you're going to get one. First thing to do is look at the business entity. Is it legally sound? And what that means is, can you pierce the corporate veil? Can you get through the corporation and get assets of the principals, the owner, the CEO? Many times your attorney will talk about that very legal strategy, pierce the corporate veil, which is valid. You want to make sure that that's an option you look at. However, that's not the only way to get to personal assets. There are many times when we have discovered that activities of third parties have enabled the fraud, enabled that company to scam you out of money, or they enabled that company to cause the damage to you. That third party could be a law firm, like we talked about. It could be a bank. It could even be one of the principals of the company. You don't necessarily have to pierce the corporate veil if you look at that owner of the company as a third party to the company, but that helped the company cause your loss, cause your damage. So when we do an investigation, we're also going to look to see, are there any is there any evidence of activities where that owner participated in the activity that caused your loss? And your legal representation or your attorney will give you good advice on how to make sure you use that to make sure that everybody who participated in the loss has a liability, has consequence. And if the owner of the company helped cause the loss in addition to the corporation, then his or her personal assets may be at risk. And that's a legal theory that a lot of good attorneys will use. Make sure the company is compliant. This is where it comes to paperwork. Did they file their annual returns properly? Did they have the right licenses? Did they let anything lapse? Because if they did and that company technically doesn't exist, now all the principals may be liable. Again, good legal advice. We're not attorneys. We're not giving you legal advice. We're just giving you descriptions of what we've seen in cases where we've done investigations for attorneys. This is where they talked about employees having risk mitigation. Well, this could help you. What if there's an employee or a former employee that has knowledge about what the company did to try to hide money or to not do risk mitigation? Let's suppose that your lawsuit against the company is for a defaulted contract. What if there's an employee or a former employee that knows that the company was aware that this contract was going to default, but they kept going forward, concealing problems, and that made your damages higher? Maybe you contracted with the company to build you a new server for your website, and they found out early on that they couldn't do it. Maybe they had in over their head, maybe they didn't have enough resources, maybe the terms of the contract weren't good. But instead of saying, look, we can't do this and we'll refund you in part friends, they tried to move forward. And maybe that moving forward caused you more harm or damages. Maybe you're a building contractor and you hired a sub to do framing and they did some damage to you because they didn't fulfill their contract. Well, if you can find that this company knew in advance that they had to default but kept going anyways, that extra loss might be a liability based on a third party. It could be an employee, it could be an owner, it could be a manager. So you want to look and see what those activities are so you can assign the liability properly. And a good investigation will look for those activities. Talking about buying insurance. How does knowledge of the debtor's insurance help you? Well, in many cases, if you present a claim to a company's insurer, they may look at it and say, we don't want to get involved, we'll just pay policy limit. Because most insurers are required to have what's called a duty to defend. They may have to defend you in court. And if they realize that even if they win, their litigation costs are going to be in excess of what it would cost just to settle and pay you, they may do that. You want to get the insurance companies involved early. Business asset protection strategy. Here's where the good stuff starts happening. They want to talk about segregating assets and operations into separate entities. Well, that's very rarely done properly. You might create a subdivision or a parent company and a shell company and put assets in one and activities in another. But unless there's very good documentation of separation and firewalls between these companies, it's all for naught. In fact, it says here, when structured properly or appropriately, each entity will stand alone for purposes of potential liability. Each affiliated entity. Well, if they're affiliated, that's one thing. If, in fact, they're really just the same company, if they're under the same roof, they have the same address, they share employees, they share bank accounts, a lot of times, even if they're affiliated, you can either show that they're really the same company, or even if they're not, you can show liability from one to the other. Again, if they took the time to separate these companies, but they all operated in concert with one another, the company that holds the assets, if they knew that the other company was causing damage, they still may be liable, even if it's shown that they were separate companies. They had separation properly created. You can show that, yeah, they're separate companies, but they're both liable. Because this other company that is holding the assets, that has $1 million in the bank, or holds trademarks or copyrights or real estate, that company also contributed to my loss because they knew It's obvious they knew. They're in the same building, and they participated in this, that they knew about the fraud and they benefited from the fraud. So this separate structures, you don't want to take it at face value. You want to dig deeper. Personal asset protection strategy. Here's where it gets even more interesting. A lot of business owners will try to hide assets in their personal name by doing trusts, foreign LLCs, equity stripping strategies. Look, the thing that we look to find and we hope to find, if we're doing an investigation and we find any emails, records, communications about equity stripping, that by itself just is a smoking gun, right? That's bad news right there for the debtor. If you can show that they even talked about equity stripping, your attorney can bring that to the court and say, look, they admitted right here they're trying to strip out equity for the purpose of hiding it from debtors. Even if that happened before your lawsuit, you can show that it's a pattern of knowing in advance that they needed to do this because they anticipated liability. They anticipated losses because of their business operations. A good attorney will make that argument in court. Foreign investment, foreign bank account, that's not a problem. Bank account searches can find that. Gifts, transfers, and exchanges. This is a good one. If you see a company or a person transferring an asset to somebody else or to another company, what you want to find is, what's the consideration? What was the in good kind opposite balance sheet transfer for that? You can't just take an asset and transfer it elsewhere without something coming back. Was there a payment? Was there a contract? Because otherwise, you can say it's a fraudulent transfer, fraudulent conveyance. If it was transferred for an artificially low amount of money, same thing. It's a fraudulent conveyance. Why would you just give away this asset for no value? In fact, most contracts have to have, especially for real estate, have to have valuable consideration that comes back from it. Again, trusts are a big deal. Marriage agreements, sometimes people will make those fake ones up. Retirement plans, a lot of times people will put money into a retirement plan to try to hide it. It says here, and again, this is a company trying to sell asset protection. The security provided by a comprehensive asset protection strategy is worth the investment. It talks about, this is like their sales pitch. Well, here's the thing. If we do an investigation and we find that there was a company hired to do asset protection, we're going to look at what their marketing is, right? If we find that this law firm, and again, we don't know if this firm is legitimate or not, we're not casting any dispersions on them, but if we find that a law firm that was hired by your debtor advertised blatantly that they're trying to do equity stripping to help them hide assets from creditors, we're going to make that part of our report. So you and your attorney will know that this is what was intended. And if you have that, sometimes that'll help you get communications. Again, attorney-client privilege sometimes will block this, but if you can show that it was done for a purpose that was not legitimate, sometimes you can push through that. Again, the company that wrote this is not being questioned, right? They're not being scrutinized. They wrote this article. They're talking about good, valid asset protection procedures. But if they're used for the wrong reasons and it's harming you, you want to know about that. And this is what happens on the other side of asset searching and asset recovery, the asset concealment and the asset protection strategy.